when you look, and I spelled it out specifically for everyone on my website, let's actually look at Missouri's Castle Doctrine. Let's dive into the law momentarily, shall we? Let's just get our toes wet. Let's just jump right into it. Over at danalash.com. And I linked everything for you. The actual state law, the statute, Chapter 563, it's defense of the justification section when you're talking about use of force in defense of persons, 563.031. Let's check this out, shall we? In fact, a person shall not use deadly force upon another person. This is for the state of Missouri under the circumstances specified in subsection 1 of the section, unless, one, he or she reasonably believes that such deadly force is necessary to protect himself or herself or her unborn child or another against death, serious physical injury, or any other forcible felony. 2, such force is used against, this my emphasis, a person who unlawfully enters, remains after unlawful entering, or attempts to unlawfully enter a dwelling, residence, or vehicle lawfully occupied by such person. Now, sidebar, the vehicle is part of the expansion of the Castle Doctrine. This is one of the things that that makes this a little bit more broader than that of other states. And number 3, such force is used against, my emphasis, a person who unlawfully enters, remains after unlawfully entering, or attempts to unlawfully enter private property that is owned or leased by an individual or is occupied by an individual. A person does not have a duty to retreat. 5, the subsection 5 on that, my emphasis, the defendant shall have the burden of injecting the issue of justification under this section if a defendant asserts that his or her use of force is described under subdivision 2 of subsection 2 of the section. The burden shall then be on the state to prove beyond a reasonable doubt that the defendant did not reasonably believe that the use of force was necessary to defend against what he or she reasonably believed was the use of imminent use of unlawful force. Kim Gardner will have her ass handed to her in court if she shows up, which is why she offered them the opportunity to bypass that and settle it out of court so that she didn't overburden the court, because she knows that she would have her ass handed to her if she were to walk into court with this. Guess what? That's a cop-out. She knows she's not going to win this case in court, number 1. But number 2, that is irrelevant to 2 people who may lose their law license because of this and be rendered felons, thus prohibited possessors, meaning they would never be able to exercise their 2A rights, again, because of the petty political persecution of an incompetent, corrupt, Soros-funded circuit attorney. I rest my case.